There are untold numbers of patients who do not have the ability to leave their state to seek care and are ultimately forced to continue pregnancies that may be threats to their health and safety. 7 states have introduced legislation criminalizing a patient or a provider for performing or obtaining an abortion. My patients come to me with a need for a service I can expertly provide. I will never interrogate my patients about their state of origin, and I know my colleagues treat their patients with the same respect. Out of state legislation that threatens our license to practice and credentialing as providers puts California practitioners at risk. Abortion care and gender affirming care are essential healthcare services. California has already done so much to be a safe haven and destination state for protecting reproductive freedom. SB 487 builds upon the state's achievements by expanding the protections for its abortion and gender affirming care providers. I'm honored to serve my patients, but I can only continue to do this safely with the appropriate protections. Please allow my colleagues and I the peace of mind to focus on the patients sitting in front of us every day and to provide them with the quality health care they deserve. Help us protect access to health, access to abortion care in California by voting yes on Senate Bill 487. Thank you.
Thank you, Doctor. Next witness.
Good afternoon, Chair Umberg and members of the committee. My name is Lisa Matsubara. I am the General Counsel and Vice President of Policy at Planned Parenthood Affiliates of California. We represent 7 Planned Parenthood affiliates throughout the state who operate over 100 health centers and provide over 1.3 million patient visits annually. I'm here today in support of SB 487 that builds on the protections for California's healthcare providers put into place by this legislature last year. Since the U.S. Supreme Court overturned Roe, abortion providers and their patients are facing an uncertain landscape with efforts in other states to ban and criminalize abortion, a safe, essential, and common healthcare service. At the same time, trans, gender nonconforming, and non-binary people are also facing an onslaught of hostile laws passed by many of these, including laws banning health services related to gender-affirming care. Unfortunately, it's become clear that California must do everything we can to ensure that patients can continue to access compassionate and evidence-based health care here in the state and protect those who provide that care. SB 487 does just that. This bill further shields providers from the impacts of hostile laws in other states. Thank you to Senator Atkins and for all of your continued support to ensure that California is a reproductive freedom state. And I'm available for any questions.
Thank you very much. Before others have to move on to other committees, let's establish a quorum. Madam Secretary, if you would call the roll.
Umberg.
I hear.
Umberg here. Wilk.
Present.
Wilk present. Allen. Allen here. Ashby.
Here.
Ashby here. Caballero. Durazo. Here. Durazo here. Laird.
Here.
Laird here. Min. Nilo. Stern. Wiener. You have a quorum.
We have a quorum. All right. Let's now turn to those who are present. One second, sir. 1 second, sir. All right. Those who are present in support, if you'd approach the microphone, give us your name, your affiliation, your position.
Ryan Spencer on behalf of the American College of OBGYNs, District 9, co-sponsors on the measure, in support.
Thank you.
Craig Pulsifer on behalf of Equality California and strong support.
Thank you.
Mr. Chair and members, I'm Erin Evans on behalf of NARAL Pro-Choice California and the California Nurse Midwives Association, both in strong support. Thank you.
Mr. Chair and members, Tim Madden representing the California chapter of the American College of Emergency Physicians in support.
Thank you.
Good afternoon, Molly Robeson with Planned Parenthood Affiliates of California, co-sponsor in strong support. I've also been authorized to provide support for the following organizations today: Equal Rights Advocates, National Council of Jewish Women California, Maya Network, San Francisco Black and Jewish Unity Coalition, American Nurses Association California, and the American Association of University Women California. Thank you.
Thank you. Seeing no one else approach the microphone, let's turn to the opposition. Opposition lead witnesses, if you're here in the room, please approach the microphone. Seeing no one approaching the microphone, anybody here who wishes to provide Me Too opposition? Seeing no one approach the microphone, moderator, if we could turn to the phone lines for both support and opposition to SB 487.
If you would like to provide public comment in support or opposition to SB 487, please press 1, then 0 at this time. That command again, 1, then 0. And we have no comments at this time.
All right, let's bring it back to committee. Questions? Yes, Senator Ashby.
I just want to thank Pro Tem Atkins for bringing the item forward, and to the witnesses who took time to come in. Senator Atkins, I'd be happy to be a co-author and at the appropriate time to make the motion.
All right, thank you. Other questions or comments? Seeing none, Senator Ashby moves the bill. All right. Seeing no other questions or comments, Madam Pro Tem, care to close?
I respectfully ask for an aye vote and thank you for your time.
Thank you. Thank you for your patience. All right. Madam Secretary, if you would call the roll.
This is for SB 487. The motion is due pass to the Senate Rules Committee. Umberg.
Aye.
Umberg, aye. Wilk.
No.
Wilk, no. Allen. Allen, aye. Ashby.
Aye.
Ashby, aye. Caballero. Durazo.
Aye.
Durazo, aye. Laird. Min. Nilo. Stern. Weiner. 4-1.
All right. Madam Pro Tem will put that on call. Thank you. All right. Thank you. Next up is file number 3, SB 490. But while we're waiting for Senator Bradford, he may be in public safety. Let us go ahead and take up the consent calendar.
So moved.
Senator Wilk moves the consent calendar. All right. Excuse me. Madam Secretary, if you call the roll.
Calendar. Umberg.
Aye.
Umberg, aye. Wilk.
Aye.
Wilk, aye. Allen. Ashby.
Aye.
Ashby, aye. Caballero. Durazo. Durazo, aye. Laird. Min. Nilo. Stern. Weiner. 4-0 on the consent calendar.
Votes 4-0 on the consent calendar. We'll put that on call. All right. Let's see. Senator Bradford is not present. I think he's in public safety. Senator Dodd, file item number 4, SB 296. Senator Durazo is here and ready. Okay, perfect. All right, let's hear from Senator Durazo. I believe that's SB 27, file item number 11, SB 27. Whenever you're ready, Senator Durazo.
Thank you, Mr. Chair, members, and thank the members and the committee staff for all of your help. SB 27 creates an ability for employees to recover their earned but unpaid wages. The University of California's equal pay for equal work policy requires vendor companies that have one of the estimated 400 service contracts with UC to pay their company employees the wages and benefits equal to what UC pays the service workers it directly employs. While the UC has responded to an earlier version of the bill last year by initiating an audit process, the impacted workers are still left with no way to recover earned but unpaid wages. To address this problem, the bill requires vendors to supply the UC and the appropriate Joint Labor Management Committee basic payroll information necessary and any audit outcomes to know if a vendor is actually abiding by UC policy. The bill also requires a vendor to supply a written notice to their employees about relevant compensation rates. Each worker will be told how much they should be paid. The bill would also allow a contracting vendor company an opportunity to correct and to cure any discrepancies before facing any consequence. If an employer still refuses to comply with the UC equal pay for equal work policy or correct and cure, employees would then have the right to pursue recovery of their earned but unpaid wages from the contracting vendor in court. The bill advances the strides UC continues to make towards third-party vendor compliance. It will not interfere with the UC's hiring ability, but it does address the problem that has not been addressed of workers getting their money, the money they earned but has been unpaid. My witness today is Monica De Leon with AFSCME 3299. Oh,
All right.
taking her place?
Yeah.
Okay. Mr. Chair, is that?
Sure, that's fine. Go ahead and give us your name.
Good afternoon. My name is Michael Avant. I'm the Executive Vice President of AFSCME Local 3299. I'm here on behalf of the service workers cleaning toilets, cutting grass, picking up trash, cooking food, and cleaning the hospital, bedpans, helping to make UC one of the greatest education, research, and public medical institution run and succeed. I'm advocating for workers who have no protection if they were to speak out today in fear of retaliation. These colleagues work alongside UC, but who works for the third-party vendors and companies doing business with UC. These workers need the recovery time of earned but unpaid wages act because they need the money and you can help them get it. UC has a policy entitled Equal Pay for Equal Work. That means for service work being performed at UC by outside vendors, those workers should get the same pay and benefits that UC employees like me receive. UC has made strides in implementing that policy. We applaud the progress, but UC has acknowledged that they are often left to rely on vendors about actual wages and benefits being paid since these vendors employ the workers. UC adopted a recent audit procedure. However, this work-for-hire procedure won't get to the fundamental problem. It won't give workers a way to recover their earned but unpaid wages and benefits. This bill will fix the problem. In human terms, SB 27 means the difference of getting their child a backpack for school, putting gas in a car, paying their utility bills or rent. This bill is fair, but the workers and their employees. Before a worker can pursue recovery time of unpaid wages and benefits, their employer will have an opportunity to cure and correct the shortfall. If the vendor refuses to cure and correct, then a worker is permitted to recover their earned but unpaid wages in court. We ask for your consideration. Thank you.
Thank you, sir. Other witnesses in support?
Mr. Chair, member Sarah Phlox, California Labor Federation, in support.
Thank you.
Thank you, Chair. Members Janice O'Malley with the American Federation of State County Municipal Employees in support.
Thank you.
Good afternoon, Mr. Chair and members. Sandra Brewer on behalf of SEIU California in support.
Thank you. All right, seeing no other witnesses approaching the microphone, let's turn to the opposition. Anyone here in opposition? If you're here in opposition, please approach the microphone. Floor is yours.
Good afternoon, Senator and Mr. Chair and Senators. Rosanna Carvacho Elliott. Sorry, I just ran down here. Representing Fidelity Investments, we are unfortunately in an opposed unless amended position. I would like to thank the Senator and her staff for the continued conversations. I would like to thank you, Mr. Chair, and your staff for recognizing in the analysis that the bill's scope is larger and unfortunately pulls in Fidelity Investments with the way the definition of services and vendor are drafted. So we're hopeful that we can have the bill drafted and take some amendments to narrow the scope so that it is not applying to Fidelity Investments. Fidelity Investments, the services that are provided for the University of California are investment management services. I don't think that is the intended scope. And with that, I would just like to, again, thank the author. Hopefully we can reach some type of agreement and go neutral on this bill. And thank you very much for your time.
Thank you. Other witnesses in opposition?
Michael Bedard on behalf of the University of California. We don't have a position on the bill, but if I could take a minute to voice some concerns and conversations we've had with the author.
All right.
Appreciate, as Rosanna said, the thorough analysis by committee staff. And to be clear, the university fully supports wage and benefit parity and the enforcement of that policy that the Regents passed at the end of 2019. We're working with AFSCME to provide the information they need to enforce these provisions in their contract as well. Our concerns are similar to last year. We're working with our suppliers to understand the impact this measure would have on our ability to fully staff our hospitals and campuses. There's a nationwide labor shortage, and we see sometimes up to 15 to 20% vacancy rates. So if there's a chilling effect where vendors are afraid to work with the university for fear of the litigation, that becomes a challenge for us operationally. We also have concerns, as the analysis points out, that the scope is too broad in the definitions of services and contracts. And we know we have 37 other bargaining units, 35 of which don't have a wage and benefit parity policy. So getting some clarity there, and conversations with the author has indicated that's not the intent. So hopefully we can fix that in the near future. And finally, I would mention, as the author said, we are working on our audit. That should be available to the public and to all of you on April 15th. When we see what, if any, compliance gaps and enforcement gaps exist from the audit, I think we'll be able to have a more complete conversation about what, if any, remedies are necessary in statute. So thanks. And
all right. Thank you very much. All right. Anyone else in opposition? Seeing no one approaching the microphone, let's turn to the phone lines. Moderator, if you would queue up those in support and opposition to SB 27.
To provide public comment in support or opposition to SB 27, please press 1, then 0 at this time. And we have one comment coming through. One moment, please, while we provide them with their line number. And now we'll go to line 34. Please go ahead.
Hello, Kathy Mancini on behalf of the California School Employees Association and Strong Support. Thank you.
Thank you.
And Mr. Chair, there are no further comments at this time.
All right, let me bring it back to committee. Questions by committee members? Yes, Senator Min.
Thank the author for this. I think it's an important bill, but I just wanted to follow up on some of the opposition. It states in our analysis, your intent is not to sweep up vendors like Fidelity, and I assume it's safe to presume that you will continue working as you always have done with stakeholders to try to clean up the bill as it moves forward.
Yes, thank you, member. We do not intend to include Fidelity or the services that they provide. It's pretty clear, I think, for us. Although I understand if they have a concern, they should raise it. That throughout the bill, there's reference to the university policy being the way that they decide the scope of who's covered and who's not. So it's at least 6 or 7, 8 times when university policy is referred to. So I think that is an important consideration. Fidelity is not performing the work for the University of California as covered in their policy. So in our opinion, the bill does not apply to them. In spite of that, yes, we'll continue to work with Fidelity and with the committee for any kind of clarification we could give.
I appreciate that. And with that,
One second. Thank you, Senator Durasso. I have to attend Transportation Committee for just a few moments, so I'm going to turn over the gavel to my capable and talented colleague, Senator Wilk. I'll be back in just a little while.
Well, thank you, Senator Durasso, for that. And with that, I would move the bill, and I will be supporting it today.
Thank you.
Senator Allen?
I'm also gotten the same call from Transportation, so I got to run over there too. But I appreciate your answer to Senator Min's questions. I think obviously you ran a similar bill last year that was vetoed, and largely based on the idea that this audit was coming. So in some respects, the bill's a little premature. The flip side is, of course, the audit's coming in less than a month, and you need to have a vehicle to respond to whatever issues come out of the audit. So I guess I would presume that to a large extent, the future of this bill is going to be determined by the findings that come out of the audit. And assuming that that's the case, I'm happy to support the bill today. But I think that audit is going to have to really help to inform where we go on this important policy area.
If I could just say something. Thank you. We appreciate that UC has, taken this as another step to try to address our concerns. The audit does not address the issue of enforcement and compliance. And so while I think it's an important tool, it does not get to the fundamental issue of enforcement and compliance. And so we're hopeful to be able to move on with what really matters to those workers, and that is to get paid. Thank you.
Anything else, Senator Allen?
Okay, so could you just give me a little more clarity as to because it's let's see here. He was, what's I guess that the governor had directly referred to the audit, and the audit let's see, I'm just trying to read the governor's veto message here. It's ultimately about enforcing their own policies that we agreed to as part of that whole negotiation coming out of ACA 14, right? So what, I'm sorry, so what, just tell me exactly what you're, where is the audit going to be insufficient to address the policy enforcement?
The audit is not an enforcement mechanism for people who did not get paid what they should have gotten paid. So we think the audit is a good tool to have, and we applaud UC for including that. However, it does not get to the fundamental issue of getting paid for wages that they've earned but have not received payment for. So again,
the audit's going to provide data.
It's a good thing, but we still have to get to, in addition to the audit, we still have to get to the issue of paying those workers what they were not paid.
Right. Because it's the audit's looking to provide data to see where there are lapses of enforcement, right? That's which is about getting people paid, right?
Well, it will tell you where who hasn't been paid, maybe. I'm not exactly sure what's going to come out of the audit. But again, we're looking for compliance, and the audit is not a compliance tool. It helps, but it's not the actual compliance.
Of course not, right? It's an audit just to
gives good information. Hopefully.
Right. Okay. All right. So this is a to be continued conversation, but thank you.
Thank you.
Okay. I got to remember transportation.
Thank you, Senator Allen. Senator Ashby.
Yeah. So first of all, just thank you to Senator Durazo. I know you've been really a good author for this bill, taking in a lot of information and a lot of input, and I've heard from folks about it as well. I'm going to vote for it today in committee, but I want to reserve my future vote to see what the audit says. And I think, like Senator Allen said, hopefully we get it. That's not, the audit's not going to change anything, but at least it would give us the information that might inform changes to the bill or changes of opinion about the bill. But I think it's important to have the audit information. I also think this is a critically important discussion, and I'm glad you brought it forward. So you'll have my aye vote today, but I'll be looking with a keen eye at what the audit says as well.
Thank you.
Senator Wilk, would you like to make a comment? Yes. My prerogative as chair. I saw this bill in labor. I laid off it in labor, again, because of the audit. This has been an ongoing issue, and I'm not sympathetic to the UC cause. And so we'll see how, so I'm going to lay off it today, but I reserve the right to vote for it as we proceed through based upon the information we get from the audit. And seeing no further comments or questions, Senator Durazo, you may close.
Yes, thank you. Thank you, Mr. Chair and members. I respectfully ask for your I vote. This is a policy we're looking to enforce that was passed in 2019. So thank you very much. Ask for your I vote.
Thank you, Senator Durazo. We've had a motion already by Senator Min, and that motion is due pass to the Senate Rules Committee. And with that, Secretary, please call the roll.
This is for SB 27. That motion is due pass to Senate rules. Umberg, Wilk,
Not voting.
Allen, Allen, I, Ashby,
Aye.
Ashby, I, Caballero, Durazo, Durazo, I, Laird, Min, Min, I, Nilo, Stern, Weiner. You have 4-0 currently.
We'll leave the roll open.
Thank you, members.
All right. Thank you, Senator Durazo. So Senator Eggman, I believe she was here first. Are we going file order? I like the assembly better. All right. Senator Bradford. You guys are hard. A lot of Umberg.
Yeah, record. Oh.
Oh, the script's flipped. We're going to take 1 minute till I can get back on schedule here with the script. All right, I didn't have it, so that's why.
I'm going to leave the door open.
All right, Senator Bradford, welcome. And you are here to present SB 490. And with that, the floor is yours.
Thank you, Mr. Chairman. As stated, I'm here for SB 490, which is a simple, straightforward measure. It extends the California task force that studies and develops reparations proposal for African Americans, and it's due to extend the sunset, I should say, to July 1, 2024. Before July 1 of this year, the reparations task force intends to publish its final report and recommendations to the California legislature. However, after the date of the task force, there will also be disbanded according to AB 3121. This poses a significant challenge to the task force's ability to engage in discussions with both the public, with the legislature to provide technical assistance in the final recommendations. Last week, every senator's office received a copy of the 500-page interim report published last year, which provides hundreds of recommendations across a variety of issue areas. Having the ability to provide technical assistance on the final report after it's published will help avoid misreporting and misinformation about the task force work. During the January 2023 meeting, the task force voted 8-1 to extend the task force. And Don Tamaki, one of the task force members who also served on the Japanese reparations task force, had a 3-year window, and he said it wasn't enough time. So this bill just simply extends the task force. It doesn't delay the final report that's due on July 1. It just gives really a firewall to the legislature once that final report is issued to answer questions and make clarity, and making sure, as you've seen, where neighboring cities across the state are implementing their own reparations suggestions and recommendations, just to make sure we're clear and on the right path, and making sure that what the final report has is correctly implemented. So I respectfully ask for I vote.
Thank you, sir. Do we have any lead witnesses here?
I didn't have one listed, but
Oh, she not a lead witness.
I didn't have.
Okay.
I didn't have one listed.
Good afternoon, Chair and members. I'm not a lead witness. I'm just here on behalf of SEIU California to support this bill. Thank you.
Thank you.
Okay, I guess we're going into other witnesses in support. Seeing none, we'll go to, are there any lead witnesses in opposition? Seeing none, any other witnesses in opposition in the room? Seeing none, we'll go to the moderator, and then we'll turn it back over to Chairman Umberg. Moderator, are you there? Because right now we'll take witnesses pro and con over the teleconference system.
Sure. To provide public comment in support or opposition to SB 490, please press 1, then 0 at this time. And we have no comments at this time.
All right, let's bring it back to committee. Questions, comments? Is there a motion? Senator Rosso moves the bill. Senator Bradford, you care to close?
I respectfully ask for your aye vote.
All right, thank you very much. Thank you, Mr. Chair. Well,
My
I
pleasure.
appreciate it, although you still left some bills to be heard, apparently. So,
I
all right.
tried.
Madam Secretary, if you would call the roll.
This is SB 490. The motion is to pass the Senate Appropriations. Umberg.
Aye.
Umberg, aye. Wilk.
Aye.
Wilk, aye. Allen. Ashby. Ashby, aye. Caballero. Durazo. Durazo, aye. Laird. Min. Min, aye. Nilo. Stern. Weiner. You have 5-0.
5-0, we'll put that on call.
Thank you, Mr. Chair. Thank you, committee members.
All right, I see Senator Dodd here, who's getting out of his chair. Senator Dodd, and then we're going to hear from Senator Eggman.
Thank you, Mr. Chair and members. Today I'm presenting SB 296 pertaining to in-vehicle cameras. Increasingly in society today, we find ourselves being recorded or surveilled with no idea of how the images will be used. Now, in addition to backup cameras and blind spot monitoring systems, new cars are being equipped with inward-facing cameras that monitor impaired or distracted driving. While there are essential traffic safety benefits derived from monitoring impaired and distracted driving behavior, there is also increasing concern that such cameras could be exploited by data brokers and other third parties who would manipulate and sell the images. My bill would prevent that, giving the consumer more control over personal information recorded by their in-vehicle camera. SB 296 would place restrictions on the retention and transfer of video recordings while still permitting important driver safety information to be analyzed and used for traffic safety purposes. It would make California the first state in the country to give consumers meaningful control over these type of in-vehicle cameras. Ignacio Hernandez and Savina Takar are here with me today in support of the bill.
Mr. Hernandez.
Thank you, Mr. Chair. Ignacio Hernandez on behalf of the Consumer Federation of California. We're the sponsors of the bill. Sorry, I was running from upstairs. Excuse me. We've been working on this issue for a couple of years, primarily because there is an increase in the use of cabin cameras. And oftentimes consumers are unaware that the cameras are there, number one. Number two, there are no regulations in place. There are very few regulations that could be argued that may be in place to control the videos that are taken inside of a vehicle. So what we do here is establish that one, the consumers must be notified that there's a in-cabin camera. Two, they must have the ability to say no, to have consent on whether or not to share it. And so we really limit that. And it's really critical because there are some consumers who may want the video in their vehicle, and there may be others who do not want it. This is Tesla, this is Lincoln, this is a number of other manufacturers that are installing these cameras, and a lot of folks are unaware. So this bill really moves it forward, establishes a format and a protocol for consumers to know. We think it's easy for the manufacturer to comply, and we think it's workable for the dealer also to comply. And for those reasons, we ask for your support.
Thank you, Mr. Hernandez.
Mr. Chair, members, Savina Takar with the Consumer Attorneys of California here in strong support. As new technologies emerge, it's important that our laws and statutes keep up. COC has been a proud supporter of these efforts, including our efforts with Senator Dodd to update our data breach laws. This is another step in that direction to ensure privacy in your own vehicles. So we align ourselves with the comments of Senator Dodd and the sponsor. We are also working with both the sponsor and the author to make sure that the language in the bill that allows access for litigation purposes is clear. So for those reasons, we urge your aye vote.
Thank you. All right, others in the room in support, please approach the microphone. Seeing no one approaching the microphone, let's turn to the opposition. If you're in opposition to SB 296, please approach the microphone.
Good afternoon, Mr. Chair, members of the committee. John Moffat on behalf of the Alliance for Automotive Innovation. We're the trade association for all the major automakers in the United States. We are opposed to the bill just as we were opposed to the bill last year. This is basically the same bill that the legislature saw last year that was vetoed by the governor. For reasons that we continue to fail to understand, the sponsors of the bill say that no rules apply to the information gathered. That's not true. The California Privacy Act applies to these cameras that are used for a number of safety reasons. You want to talk about increased notification? We are absolutely open to that. You want to talk about a prohibition on advertisement? We're open to that. You want to talk about a prohibition on sale? We are open to that. But as the bill is drafted, it switches the Privacy Act's opt-out mechanism to an opt-in mechanism. It defines personal information in a different way in this bill than it does in the California Privacy Act. This bill uses consumer devices. I thought the bill was about cars. Why are these devices in the definition of personal information in the bill? Last, we don't think it addresses the governor's veto because it puts the safety information in the opt-out part of the bill, or excuse me, in the opt-in part of the bill. If you're an alcoholic buying a car and you know that the car will shut off if you're drunk driving, are you going to opt in to that information or are you going to opt out? My guess is you're going to opt out. And so we think it suffers the same problems that last year's bill had, and we ask for a no vote.
Thank you.
Thank you, Mr. Chair and members. Dylan Hoffman on behalf of TechNet. We also respectfully oppose SB 296. Align my comments with my colleague, but just want to expand on a couple of points. Similarly, we don't oppose the bill's prohibitions on advertising or the sale of this information. We also believe in increased consumer disclosures, and I think those provisions are appropriate. I think just the provisions related to the sharing of this information could use additional tailoring, as well as the anti-discrimination sections. We know why that's in there. However, I think as applied could potentially mean that we're required to provide the same level of product and service. But if a consumer fails to opt in and we're either not able to update the cameras or we're not able to offer the service entirely, whether it's drowsy driving prevention, we're arguably not able to provide the same level of service, and so would therefore be liable to sue under that provision. So just wanted to point that out as well, and look forward to continuing our work with the author's office to continue to refine those points, address some of the need for this bill. So for those reasons, we respectfully oppose. Thank you.
Thank you, Ms. Hoffman.
Good afternoon, Mr. Chair, members. Ronak Delami on behalf of the California Chamber of Commerce. We align our comments with our colleagues at the Alliance and TechNet, respectfully in opposition. Thank you.
Good afternoon, Mr. Chair and members. Dan Shaw with Omni Government Relations here on behalf of the Civil Justice Association of California. Also,
thank you. Anyone else here in the room? Seeing no one else in opposition, let's turn to the phone lines. Moderator, if you would queue up those on the phone lines, both in support and opposition to SB 296.
To provide public comment in support or opposition to SB 296, please press 1, then 0 at this time. And we have no comments over the phone.
All right, let's bring it back to committee. Senator Min.
Permission to ask a question of the opposition witness?
All
the
right.
First one from the auto dealers. So I have to confess, I was not aware there were internal facing cameras. Is this something that if I were to buy one of these cars, I can opt out of when I purchase it? And is this something that's clearly communicated to me that these cameras are?
Yeah, there's going to be notice in your owner's manual that the vehicle, not all vehicles have these, right? The National Transportation Safety Board has made a recommendation that all vehicles.
But you're saying it's in the owner's manual. It's not in, like, it's not presented up front to me. So I might very well purchase one of these cars and not be aware that it has internal facing cameras.
I'm with the automakers,
okay,
not the auto dealers, the folks doing it. And again, we don't object to the notification provisions of the bill.
But I guess let me just take it back. Why shouldn't it be opt out? I mean, if that's the big, or opt in, Because like this is not Instagram. I'm not posting pictures of myself. I'm not purchasing a car typically to like post myself on social media or to share, footage of myself. I'm purchasing a car to drive, right?
Sure, yes, you're purchasing a car to drive with technology that these safety features and other
Do
features.
you
are
think the
built
average
into the car
consumer
for
like
those
wants to
purposes.
purchase a car with the intent of having their information broadcast
This information isn't broadcast.
or shared with manufacturers, shared with whoever else might?
If it improves the safety features of the vehicle, I think yes.
I will tell you, I've purchased a few cars in my life, and I had no idea these cameras existed. I had no idea they would be taking footage of me, and I think that's a real problem if that's not being clearly communicated to people at the point of sale. But I guess I don't understand what the argument is for not allowing an opt-in. If this, again, the primary purpose of a car, yes, we want it to be safe, but it's to drive a car, right? When I purchase a car, I'm not purchasing it to take surreptitious footage of me, right? Like I imagine your average consumer is not purchasing a car with that in mind.
And again, we don't object to the notification provisions of the bill. We don't object to the ban on sale. We don't object to the ban on advertising. I think you're thinking that the cameras are taking pictures of you and sending it to the auto
Well, they're taking
manufacturer.
video footage of us,
They're
right?
they're digitized images that are used to help improve the technology and software for those safety features. That's all we're trying to preserve here, and saying that that information, again, consistent with California's Consumer Privacy Act, which means it's de-identified and aggregated so that it can be used to improve the safety software of the vehicle. From our perspective, we look at that and say, okay, if it's consistent with California law and California's privacy law, which applies to phones, televisions, all of the other consumer devices that are out there, we think an opt-out approach is the appropriate approach consistent with existing law, so that information can be used to improve that technology on a going forward basis.
All right. Well, thank you for your answer. Appreciate that.
Thank you. Other questions, comments? Seeing none. All right. Is there a motion? Senator Min moves the bill. All right. Senator Dodd, you care to close?
Respectfully ask for your aye vote.
All right. Madam Secretary, if you would call the roll.
This is SB 296. The motion is to pass the Senate Appropriations. Umberg.
Aye.
Umberg, aye. Wilk. Allen. Allen, aye. Ashby.
Aye.
Ashby, aye. Caballero. Caballero, aye. Durazo. Durazo, aye. Laird.
Aye.
Laird, aye. Min. Min, aye. Nilo. Stern. Weiner. You have 7-0.
7-0, but we're going to put that on call. Thank you, Senator Dodd. Next, we have Senator Eggman, who's been patiently waiting. After Senator Eggman, then Senator Menjivar on SB 457, and then Senator Portantino on SB 712. Senator Eggman.
Thank you very much, Mr. Chair, members. Today I am presenting before this committee SB 267, which would allow prospective tenants with a housing voucher to submit alternative documents demonstrating their ability to pay in lieu of a credit score. So as we all know, you go to rent something and you got to give up your credit score. So when I first learned about this, I was with my housing director, who's here to testify with me today. And they talked about the difficulty of people who have vouchers to even be able to use those vouchers. I think less than half of the ones that we have provided for people to get housing go unused, because oftentimes when people go before to try to apply, they run a credit score. Well, if you've been homeless, if you've had a really hard life, you probably don't have a great credit score. You might have a stain on your credit score. Today at lunch, I dropped on my jacket. I have a stain on my jacket, just as some people have a stain on their credit score. It's not something you want, but it's something that's part of life that happens sometimes. This bill simply says, and you heard it last year, got all the way through this House with bipartisan support, got a little bit held up a little bit in the Assembly. This only says, and again, a voucher is going to pay between 70 and 80% of a person's rent. This just says that they can provide alternative information. Could be pay stubs, could be their last person they rented from, to be able to say, yeah, I know my credit score is not great, but my life is turned around. I have a housing voucher. I have my kids. The government's going to pay this portion, and I can pay this portion based on my pay or whatever else. So that's all this bill does, is allow people a shot who might have a stain on their credit to not have to carry that with them the rest of their life and be able to get housing. We must address our homelessness issue, our housing issue. This is one more tool to put a little bit of compassion and a variation in what landlords can look at. And with me today, I have Peter Ragsdale with my housing authority.
All right, Mr. Ragsdale.
Good afternoon. Thank you, Chair and members. Thank you, Senator Eggman, for bringing forward SB 267. The Housing Choice Voucher Program, formerly known as Section 8, helps struggling Californians afford rent, which we know is incredibly challenging in California. 13% of Housing Choice vouchers nationally are in California, representing about 340,000 vouchers that we'd like to see deployed in our state. Vouchers typically support 70% of a household's rent, paid reliably to participating landlords. Vouchers are intended to keep family housed for as long as it takes. And if this means if income goes down, payments go up and the family is prevented from falling into financial spiral or worse, homelessness. These households are often the most vulnerable Californians. 67% of voucher-assisted households include the disabled, seniors, and children. Vouchers are a primary tool to bring the most vulnerable Californians off our streets and stop new households from adding to the state's homelessness crisis. Unfortunately, the need for housing subsidies greatly outstrips supply. To get a voucher, wait times are often 2 to 5 years or longer. Finding available units and landlords willing to participate is profoundly challenging for both housing authorities and voucher participants. Landlords are often reluctant to accept the voucher for fear of the perceived risk of an administrative burden or the perception of low-income renters. For the people we serve, low credit scores reflect the cost of living and the wage gap. 89 hours of work are necessary to afford a one-bedroom apartment on minimum wage in California. Increasing rents have only exacerbated the problem, especially for the most vulnerable Californians. In San Joaquin County, less than half of the households issued a voucher locate and are accepted for a rental property. Known as the voucher success rate, this is common across our state. A low credit score or credit invisibility needs to consider the support offered by the voucher, expanding housing opportunities for low-income families. As folks search, rent money sits idle, support sits idle. And candidly, with ARPA, there's been a bright spot, which gives us hope that this is possible, that the American Rescue Plan, California received 17,000 emergency housing vouchers in late 2021, receiving over 24% of the national allocation. Statewide, our utilization is 67.8%, representing 11,542 households. We've been able to lease up 129 households in San Joaquin County, representing 357 individuals that have transitioned from homelessness. Voucher programs work and provide an amazing public-private partnership to housing affordability and mobility. As communities consider more innovative solutions to see vouchers utilized, including landlord incentives, occupancy loss payments, and damage mitigation, removing the barrier of a good credit history for low-income families will actually have dollars turned on in California. I urge this committee to support SB 267. Thank you for your time.
All righty. Others in support? Other witnesses in support? Others in the room who wish to provide their name, their affiliation, and their position?
Mr. Chair, member Sarah Phlox, California Labor Federation, in support.
Thank you. Others in the room, seeing no one else approach the microphone, let's now turn to the opposition. Opposition?
Good afternoon, Mr. Chairman and members. Deborah Carlton with the California Apartment Association in respectful opposition. We have a very good working relationship with Senator Eggman and would like to continue to do so. I think what we're looking for today is to ensure that that information that is provided is verifiable, right? We have other portions of the code that do provide that any information provided by any others, not including the subsidies, is legal and verifiable. So, you know, we do believe that it's important that individuals with a rent subsidy do not face discrimination. In fact, we cannot discriminate because they have a rent subsidy. So we would like to continue to work with the senator to find a solution to that evidence that is provided that is separate from the credit report. Thank you very much.
Thank you. All right. Others in opposition?
Mr. Chairman, members, I'm Ron Kingston, representing the Apartment Association Orange County, East Bay Association, and the Affordable Housing Management Association that literally caters to every low-income tenant there is for seniors and disabled, as well as the very low-income households. here's our sole concern, is that the information that the applicant, not tenant, but the tenant applicant that provides this information has certainty, and we can rely on it as really credible information. The tenant's portion of a Section 8 payment, that's what we look at. We look at, one, the certificate or the housing choice voucher, and then how much is the tenant earning and how much can they devote to paying rent, as well as all the other obligations for food, for a number of other essential services. And sometimes that amount is overwhelming and we can't qualify the tenant because they have too many financial obligations, or they have failed to perform and are not able to meet those obligations. And we need to have that opportunity to do so. We would like to ask the senator to include and address these very factual, real life issues because of what we face each and every day when an applicant comes to us and say, we would like to rent from you. Thank you so much.
Thank you. Others in opposition?
Mr. Chair, Senator Dean Garofalo on behalf of the California Rental Housing Association respectfully opposed to SB 267.
Thank you.
Mr. Chair and members, Pat Moran with Aaron Reed and Associates representing the Southern California Rental Housing Association in opposition. Thank you.
Thank you. Others in opposition? Seeing no one else approaching the microphone, let's turn to the phone lines. Moderator, if you would queue up those who are in support and opposition, SB 267.
To provide public comment in support or opposition to SB 267, please press 1 then 0 at this time. So far, we have 5 comments queued up. First, we'll go to line 38.
Good afternoon, Chair and members. Amar Rashid with the County Behavioral Health Directors Association of California in support. Thank you.
Thank you.
Line 36.
Good afternoon, Chair and members. Ina Rosales with the Western Vermont Poverty in support.
Thank you.
Line 24.
14th California Reparations Task Force is scheduled for March 29th and March 30th.
All California Reparations Task Force meetings are open to the public and welcome public comment. Amend the Mass Media Group provides coverage of all California Reparations Task Force meetings. Tune in, tap in, and testify. Reparations Now, fam.